Hello, good morning. Happy Saturday. My name is Megan Mays. This is Being Civil in Minnesota. I come here Saturdays at 10 to talk about family law and the court system. I think there's a lot of great information on the internet, but I think there's a lot of terrible information on the internet. So I like to do these so people have free resources. Good morning, guys. This does not make me your lawyer. I am a lawyer licensed to practice in Minnesota, and I am a qualified mediator. But this is just a place for resources and information. So if you have questions, go ahead and post them in the chat. Today's topic is about guardian ad litems. And we chose this topic today because somebody in the Being Civil in Minnesota Facebook group had questions about what a guardian ad litem is and what the process looks like. You can ask questions anonymously, and I answer them on our Facebook group, or I choose them as topics for our weekly podcast. The group on Facebook is Being Civil in Minnesota, and you can find 44, I think, episodes on the YouTube channel Being Civil in Minnesota. Guardian ad litems are by statute. They are individuals who are appointed by the court to advise the court on custody and parenting time that is in a child's best interest. There's a statute 518.165, and that talks about the process and the types of appointments for guardian ad litems. And there are two different kinds of appointments. One is a permissive appointment. You can ask a judge at any time to appoint a guardian ad litem in your case. Guardian ad litem is a neutral individual that is going to do an independent investigation, review information, conduct interviews, and make a report back to the court on what is best for your kiddo. Permissive appointments are very hard to get. Guardian ad litems are required in like child protection cases, And so there is a need for those cases where a child is being abused or neglected. Because those cases get priority, there are not always enough guardian ad litems for permissive appointments. The Guardian ad litem board has, they have limited resources, and even when cases are mandatory, sometimes you have to really advocate to get a guardian appointed because there just aren't enough guardians out there. When is a guardian required? Well, it's not going to be required in your family law case if you already have like a CHIPS case going on. But if you are in family court and one of the children is believed to be a victim of child domestic abuse or neglect, and those are defined by 260C.007, that is when the guardian must be appointed. So I went through and I kind of looked at what does domestic child abuse look, sound, feel like? What does neglect look, sound, feel like? So the required appointment is when a child has sustained physical injury by a family, an adult family or household member, other than by accident. So if a child does get hurt and it was an accident, they are going to look at did the person intend to actually hurt this child? Sometimes it can be hard to tell. Kids can be scared, and perpetrators or abusers can often exert power or control. And so that can be a very hard distinction to make. Now, the rules do exclude what they call reasonable or moderate physical discipline. In the state of Minnesota, parents are allowed to use reasonable or moderate physical discipline, cannot result in injury. So if the physical discipline or, is to the point where it's leaving marks or causing injury, that is no longer moderate discipline. That rises to the level of domestic child abuse. If you have a case where a child has been subjected to sex trafficking, prostitution, sex extortion, or criminal sexual conduct, again, a guardian ad litem is required. Then a guardian is required if a parent is impacting a child's physical or mental health and causing injury to their capacity or emotional stability. There needs to be what's called observable or substantial impairment. You're going to typically, in cases like this, if you believe that your kiddo is struggling, therapy is a great place for that and those feelings to be explored. If they have a mental health provider, that provider may be able to provide some information or documentation to indicate whether or not the child is acting or behaving normally, or if something is causing them to be impaired or diminished capacity. Not always is a therapist going to be able to say, and the cause of it is X. So you're still going to have to sort of probably tie the limited mental functioning of your kiddo and the behavior of the abuser. So guardian ad litems, what do they actually do? So they are appointed by the court, and there is a fee associated with this. And the court can have one or both parties pay that fee. There are certain kinds of cases where fees for a guardian are not required. So you want to make sure that if your case is in front of the court, that you have asked whether or not a fee is required for your kind of case. So guardian gets appointed by the court, and the court sets the time frames. Sometimes a court wants a report back from a guardian within 30 days. That can be a short turnaround time if the guardian has to meet with multiple children in multiple settings, review records, but they get it done. More often you're going to see an appointment that lasts more like 60 or a deadline for 60 or 90 days for the report to be done. While they're doing their report, they are conducting an independent investigation. They're reviewing docs, they're meeting with the kiddo, maybe in both parents' homes. They are interviewing collateral witnesses or other caretakers or individuals that may have information to share with them: school counselors, teachers, pastors, therapists, individuals that may have some relevant information as to what is going on and how the guardian can best advocate for what is best for the children. They're going to advocate for that kiddo based on the best interest factors. There are multiple factors in the state of Minnesota. We've gone over those and talk about things like, what are the child's wishes? Are the parents chemically dependent, or are they healthy? Do they have any mental or physical impairments that might impact their ability to parent? Are the child's needs being met? All of these things are going to be considered. And then the guardian has to put that information into a written report. And they have to identify what facts they are relying on to make that recommendation. So if the guardian is going to recommend full custody to one parent or limitations or restrictions on parenting time, that report is going to include the reasons and the facts underlying why or what reasons the guardian had for making those specific recommendations. On the Minnesota Judicial Branch, I believe it's the 4th Judicial District, they have a form on the Minnesota Judicial Branch that is a outline or a blank template of what their guardian ad litem reports look like. You can take a look at that and kind of see what information might be put into the report. And then what happens with that report? Well, it gets filed with the court and shared with everybody. And then the court is going to review that and make an assessment based on the guardian ad litem's observations, information reviewed, and recommendations. They're going to review that information and decide if they are in agreement with the guardian ad litem that based on the information that was obtained, that the recommendations make sense and are in the best interest of the kiddos. A lot of times the guardian ad litem's report is going to be given a significant amount of weight. So you'll want to make sure that you are staying in contact with your guardian ad litem, that you are signing any releases that they want. Their job is difficult, and so anything you can do to ensure that you are providing timely, helpful information is great. Guardian ad litems are a great resource and oftentimes are required if, for example, a parent wants to change parenting time because they believe that the child is in danger. Well, if the danger is based on physical, sexual, or mental or neglect issues, that would be a good time for a guardian to be like, okay, I see that you're concerned, but what is really going on here? And then report that to the court. If you have any other questions about guardian ad litems or the guardian ad litem process, you can post them here, or you can post them anonymously on the Being Civil in Minnesota Facebook group. I will be here again next Saturday at 10. So please take a look at the videos on the YouTube channel and have a great rest of your weekend. Take care.